afternoon. We are starting the next briefing, and now we'll be talking about the problems with the procedure for entering Crimea. We'll demonstrate some examples. In the beginning, I would like to introduce our speakers. Martynovskyi, a lawyer. Oleksandra Romantsova, project coordinator. Dmytro Makarov, lawyer from Russian Federation, and I'm Tetiana Pechonchyk, head of the Center of Human Rights Information. I would like to first of all explain the background. The existing procedure for entering Crimea creates obstacles for journalists and lawyers in the Crimean Peninsula. This all started back from the resolution of the Cabinet of Ministers of Ukraine number 346, which regulates the procedure of entering temporarily occupied territory of Crimea. That resolution was passed on the 4th of June 2015. Basically, if we remember, half a year before that, in December 2014, the railway transportation communication with Crimea was stopped, and then introducing this procedure hit the opportunity, the possibility for Ukrainians to enter Crimea, and it made impossible for foreign journalists and lawyers to human rights activists to work in Crimea, because all foreign citizens have to receive the special permit to enter Crimea. But the journalists and the human rights activists were not included into the list of people who were allowed to enter. In autumn, the Cabinet of Ministers passed new resolution number 722. That was in September 2015. And this resolution introduced amendments to the procedure, which improved the procedure, because that included such categories as journalists, international independent human rights missions and activists, but this did not influence the real possibility for foreigners to visit Crimea. And there's still a problem with the citizens of Ukraine. Unfortunately, on the territory of the occupied Crimea, Ukraine as the state cannot independently defend the rights of its citizens, but very often it puts obstacles for those who are ready to do that. For example, lawyers and human rights activists. And now only Russian lawyers can defend the rights of citizens, and all the trips of Russian lawyers to Crimea are beyond the Ukrainian law, and all of them are violating the Ukrainian law. But the procedure itself is very long, bureaucratized, and it puts obstacles for independent, for the work of independent journalists and human rights activists. I would like to give the floor to Oleksandra Romantsova, who will in more detail tell you how she was helping to get a permit. Thank you. The Center of Civil Liberties is interested in the work of independent journalists in Crimea. And that is why our partners come to us, so that we help in the procedure during the first stage, which is applying to the Ministry of Foreign Affairs for the international representative office of some international organization in accordance with the law could do that, could get the permit. For that, they have to receive, that they have to make the Ministry of Foreign Affairs to send the request to our immigration service. But according to our experience, our first request to the Ministry of Foreign Affairs was processed for more than a month. That was probably the first time they were doing it, but more than a month. That does not even correspond to our legislation as to requests from the citizens. When finally we received such a permit, and when we then went to the state customs service, we were faced with such problems as, in order to submit the documents to the customs service, the person has to personally do that. It is impossible to do that in a different language than Ukrainian. So the person either has to have here the interpreter, the partner, and the person has to come here physically. And the next thing is, according to the procedure, after this permit is considered, after the customs service finds the letter that was sent by the Ministry of Foreign Affairs, after that, more than 5 days, they were considering this. They were considering it for 7 days. And we made the power of attorney, and the first question was, why do you have the power of attorney from Russian notary? That was the doubt of the worker of the state customs service, and we received these documents. And then we saw that the permit was issued for 90 days. The days are counted from the last stamp of the entry of a person. When this permit finished, we applied second time, and they refused to give the second permit. The procedure is such that it's basically at the discretion of the people in the state customs service to decide whether they can do it or not. So those people who can take care of defending the rights and freedoms of the citizens of Ukraine on the territory of Crimea, we demand the person to violate the law. We force the person to violate the law, and people are just traveling from Moscow to Simferopol. Do we want it? No. I believe this procedure was designed to limit the presence of foreigners without control, but Ukraine has no method of controlling how many people like that go to Crimea via Moscow or other cities of Russia. So on the one hand, there are people who respect our law, and we put obstacles to them, and those who do not respect the law, they are just flying from Moscow to Simferopol. And we as as human rights organization, we really don't want to this to continue. So basically, Alexandra told about how such procedure creates obstacles for the foreigners who want to follow Ukrainian legislation. They spent a lot of time and money to get these special permits, and others, they just directly fly from Simferopol to Moscow and back, and the state has no control over that process.
Присутній Дмитро Макаров, він близько 2 років був.
Dmytro Makarov was the deputy head of the field mission on human rights in Crimea, which started to work in Crimea in March 2014. All that time, it was the only international civil rights, human rights initiatives that was monitoring the situation in Crimea and was a reliable source for all, and that was Ukrainian-Russian initiative. And Dmytro, after this new procedure was introduced, already received the refusal to enter Crimea. And I would like Dmitry to tell us about what he thinks about that.
As Tetiana told us, starting from March 2014, I work in the field mission, and also starting from 2014 in the center that tries to ensure that monitors are present in Crimea. And our requirements are the increase of the number of such monitors and also permanent presence of monitors in order to oversee the adherence to human rights. And this was supported by the Minister of Foreign Affairs of Ukraine, that he said that international presence should be in Crimea, and there should be representatives of Council of Europe, and this is one of the components that is important in the policy as to Crimea. And in 2016, I addressed for the possibility to enter the Crimea, and the services told me that I didn't provide grounds for the presence in Crimea. And before this, we spent several weeks together with our colleagues. We negotiated with the Ministry of Foreign Affairs in order to get this letter. And Migration Office, they believed that if I entered on the ground this letter, so I should go there on the ground of the next letter from the ministry. And they told me this. And as my colleagues told you, there is a paradox situation that those advocates of human rights and journalists who try to adhere to the laws of Ukraine, they face different bureaucratic obstacles. And the permit that was given to me for my first request was for 90 days. And I asked why this is for such a short term. And they told me that I have the right to be in the territory of Ukraine for 90 days. And these 90 days, that they can be in the year, as in other states is provided, not for 3 months. And every 3 months, if I want to follow the laws of Ukraine, I should undergo this procedure. That is, first I should address to the Ministry of Foreign Affairs that consider my address and for 30 days, and they have time for the answer. And then I should go to Migration Service of Kiev or any other city of Ukraine. Then I should apply the documents, and I should wait for 5 days. And after this, I should and I should go by land transport, and it's time and money consuming. And imagine that, for example, a lawyer who should attend a court hearing, or a journalist who heard about some events, or an advocate of human rights these people, they face these bureaucratic procedures that are excessive. And also there are some requirements from people that need their rights to be defended. And many of my colleagues, advocates and journalists, they won't go along this expensive and time-consuming procedure. They just will get on the plane and in Russia and go to Crimea. And what should be the reaction of Ukrainian state? First, the criminal investigation should be started. And in reality, we see that Ukraine welcomes this activity. And the Minister of Foreign Affairs and other public officials, they addressed to Russian advocates that they should defend the Ukrainian citizens in Crimea and ask international missions and representatives of national organizations that they should go there. They don't ask to go along this procedure. And we believe that this is a strange situation. The procedure should be different. It shouldn't be so bureaucratic. And we should not even, for example, that I would like to visit Crimea. If there's some grounds, they can say that they don't want to see me there, and that they see it as a violation. And this is a normal situation, and we are ready for this. So there should be a procedure envisaged for this. And secondly, as I see it, legislation on rights, on human rights in the temporary occupied territories, they should be added by one article that in special situations there are some exceptions, and some people can go to Crimea from the territory of Russia, as we see it in the case of diplomats and also Russian advocates, because they don't have possibility and they don't have time to go by this procedure, and as I tried to follow, and I saw a refusal and a lot of difficulties in my way. And if Ukrainian authorities are interested in international presence in Crimea, as it is declared in the law on human rights and defense of human rights in the territory of Crimea, so they should revise their views in this respect. Thank you. Thank you, Dmitry. And this procedure is not about foreign citizens, but also the citizens of Ukraine, but this is a violation of the law. And this procedure envisages the regulation of entrance of foreign citizens in Crimea. And I would like to tell you, I would like to give the floor to Martynovskyi. Thank you, Tetiana. We are criticized that we are not satisfied with actions of power. But we believe that we should not be satisfied with the actions of the power, because there's always ground for the criticism. And so we as advocates of human rights, we should be concerned. And of course, we deal with these procedures, and a special working group was created, and I took part in this working group. And it was envisaged that we will be able to take part in the development of these procedures, but it didn't happen. And this procedure was taken with the only observation of ours, that is to the necessity to provide written refusal, written rejection in crossing the administrative border. And in June, we submitted, we filed a case to the court, and we insisted that the Cabinet of Ministers didn't have the rights to regulate the procedure of entering to the occupied territories. There is Article 10 of the law on occupied territories, and it is said that the citizens of Ukraine have the right for free access to the temporary occupied territories and exit of these territories if they have documents, ID, and that these people are the citizens of Ukraine. And one more condition is that the crossing of the administrative border in checkpoints that are in Kherson Oblast. And Article 10, it is said that the Cabinet of Ministers should develop and adopt a special procedure for foreigners and stateless persons. And these provisions, in these provisions, the Cabinet of Ministers exceeds its responsibilities. And paragraphs 38 and 39, there are some refusals and rejections. For example, if there were some violations at customs control, and people who crossed this administrative border, they understand me and they support me that it's very easy to violate rules there, because you don't know in what zone you are, whether it is a zone of customs clearance or a frontier. So if we lawyers, we don't even know what is in this procedure. So it's very difficult for laymen to understand. And these points 38 and 39, so there are cases when citizens are refused to go to these territories. So first instance court, for example, in 2015, and appeal court in January 2016, they refused our plea, and at this we said that when this procedure violates the requirements of Article 8 on counteraction to discrimination, that envisages anti-discrimination expertise, and the law rejected our requirements, and the procedure was like it was before. And also in September 2015, we didn't change our application because 722 provision, it doesn't make any changes to this procedure. So the courts continue to take decisions. The procedures and policy is the same. When we are speaking about the grounds for not the law is on the first place, but political necessity prevails. And there are some political vectors in our state. You understand what is going there with the law in this case. And what are the prospects of our address to the court? I don't have any illusions about this, that this procedure will be cancelled in the Ukrainian courts, and we believe that we can find justice only in the European Court of Justice, and we should deal with this issue. We should cancel this procedure regarding Ukrainian citizens, and the provisions 38 and 39, they should be reviewed. And also, if Ukraine will come to this, it won't create normal procedure without introduction of changes to the law on occupied territories.
Дякую. Власне,
Thank you. So summing it up, I would like to say that we are demanding to exclude from this procedure what relates to the citizens of Ukraine, and we are suggesting to simplify the procedure for foreigners so that it's not a permit type procedure, but notification type procedure to allow foreigners to supply documents not just in Ukrainian and English and other languages, to give them the chance to submit these documents, not physically, personally, but via consulate authorities abroad, and also expand the category of foreigners who could get such a permit, to include lawyers there, to make this list open, not close as it is now. These are our main requirements, and we are ready to answer your questions. We have time for one or two questions. If you do have them, you're welcome. Okay, no questions. Thank you. See you again.